As everybody says, Riccardo Guastini is one of the most important Italian legal philosophers. But this may just sound like a statement of courtesy. For this reason, I will go further and say that, in my opinion, Guastini is more precisely the most important Italian legal philosopher. I must also confess that Guastini is one of my habits in the following sense. With respect to Guastini, I usually do something that I previously used to do with Bobbio. When I begin to study a subject of legal theory that I have not studied before, the first thing I do is to read what Guastini has written about it. Guastini has written about almost every subject of legal theory and has always written about it with a remarkable clarity. Therefore, I am sure I will find in Guastini's text a clear statement of the problem or problems involved and an approach to them that, no doubt, will also be clear. And this approach will also be, in most cases, in my opinion, highly controversial. But a clear, well-willed, and highly controversial approach is the best thing to make you start thinking. To begin to think not only from it, but also, if you will, against it. But thinking is, in my view, an activity that is best done precisely when it is done against someone. I have described Guastini's approaches as highly controversial. Highly controversial is here a polite way of saying that I often disagree with them. They are highly controversial in my opinion, and I often disagree with them because they are usually linked to two central features of his philosophy which I disagree with. One of these features is ethical irrationalism, and the other is what Guastini himself and his colleagues from Genova call the skeptical theory of interpretation. As for ethical irrationalism, Guastini has always remained faithful to a position in the Kelsen-Ross-Bulligin line in legal philosophy or in Stevenson line in general philosophy. As for the skeptical theory of interpretation, however, I believe Guastini has been oscillating between two positions, a more radical one and a more moderate one. According to the radical position, which is present in some of Guastini's texts, meaning doesn't exist until the intervention of the interpreter. The normative authority, the legislator, issues mere significance to which the interpreter could ascribe any meaning without any limitation. According to the more moderate position, which is also present in other of Guastini's texts, he endorses in this respect a position similar to that of Kelsen's. The normative authority issues a framework of possible meanings within which the interpreter discretionarily chooses one of them in an act of will which cannot be subject to a rational foundation. The title of Guastini's paper is, as you know, Juristenrecht, Inventing Rights, Obligations and Powers. The very title suggests that the skeptical theory of interpretation is going to be present in it, and the title also suggests that it will be present in its radical version. But one never can be sure. To confirm that, or to be surprised by Guastini, I give the floor to him.
Thank you very much, Juan. You know, Juan Ritmanero is one of my best friends in Spain, and so I'm not surprised by these kind words, but listen to this kind of word, one would wish to disappear. And thanks also, and most of all, to Jordi Ferrer, who is the organizer of this conference. Well, my paper is about neutrality, or rather non-neutrality, not in legal theory, but in legal scholarship, or legal science, legal dogmatics. My point of departure is just a matter of course, is Jeremy Bentham's distinction between expository and sensorial jurisprudence, a distinction shared by, although with slightly different formulation, shared by John Austin and Hans Kelsen. Everybody knows such a distinction for sure, and there is no need to repeat it. Well, Bentham, Austin, and Kelsen aimed at distinguishing the value-free knowledge of the law, A, from the moral or political criticism and or approval of the existing law, as well as B, from legal policy, namely directives de lege ferenda addressed to the legislator. Nonetheless, their characterization of expository jurisprudence as a pure cognition of the law as it is, hence a purely cognitive, value-free enterprise, cannot be taken as a satisfactory description of the actual practice of academic lawyers. Rather, it should be understood as a normative model of legal science, in inverted commas, since almost every book or paper or essay usually claiming to be and actually considered as a piece of legal cognition, I refer to legal writings such as textbooks, monographs, commentaries, and so on. Well, with a special look, I have to say, to continental legal scholarship. I'm not sure that I can extend my thesis to Anglo-American because I don't know the issue so well. Well, almost every book usually considered as a piece of legal cognition cannot be reduced to a merely cognitive enterprise. In the common usage of continental jurisprudence, the ordinary juristic work is frequently labeled as legal science, legal doctrine. Well, it is a bad translation probably of the Italian dottrina giuridica or the French doctrine, but legal dogmatics, legal science, legal doctrine. Nonetheless, all such phrases can be understood as pointing to at least two quite different intellectual enterprises which ought to be distinguished. On the one hand, legal science, properly so called, Kelsen's science of law, Austin's science of jurisprudence, that is, the scientific, neutral, value-free description of the law in force, on the one hand, and on the other hand, what I shall call legal scholarship. I'm not sure this is a perfect translation, but I hope everyone within you understands what I mean. Legal scholarship, that is the usual academic investigation into the law, especially into those normative texts which are regarded as the official sources of the law. Now, legal science, strictly understood, and legal scholarship are different matters. The main difference between them, however, is not the same as between describing and evaluating or prescribing. Sure, from time to time, academic lawyers do evaluate, that is, criticize approve or justify the law in force. Sometimes they also make statements de lege ferenda, that is, directives belonging to the realm of the art of legislation in Bentham's terms, or the art of government in Kelsen's language. But in such circumstances, however, they don't usually claim to act as genuine scientists. Well, the non-neutral character of legal scholarship lies elsewhere. And this is the specific subject of my paper. Now, just a premise, what I'm going to do is just the discovery of the umbrella, or the hot water. But anyway, in common juristic usage, the legal academic work as a whole is often labeled as interpretation, without any further specification. However, such a use of the term interpretation is definitely too large. Its main fault is overshadowing the variety of intellectual operations actually accomplished by legal scholars. Since interpreting, properly understood, is but a part, and not the most important, I dare say, of actual juristic work. Side by side with interpretation, jurists accomplish a great deal of other operations too. I propose to label them juristic construction. Interpretation, stricto sensu, consists in ascribing meaning to normative texts, such as statutes, the Constitution, and so on. The standard form of an interpretive sentence, I assume, is T means M, where T stands, as a matter of course, for the interpreted text, while M stands for the ascribed meaning. Interpretation. Juristic construction, in turn, in the sense I'm going to use the phrase, mainly consists in shaping unexpressed rules. That is, rules or norms, if you prefer, that no normative authority, no law-giving authority ever formulated. Rules that cannot be ascribed to any definite enacted text as its meaning, content, or direct logical, deductive implication. In most cases, the grounds of such rules, like non-expressed rules, are juristic theories. I use this term because I ain't got any other. Theories, entre comillas, in inverted commas. I mean, I have in mind such theory as the competing theories of equality, the competing theories of civil liability, the theory of parliamentary government, the theory, remember Marbury, the theory of written constitutions, the theory of the relationships between European law and the domestic legal systems of the member states. The doctrine, another good example, the doctrine of incorporation of rules of international law in municipal legal systems, and as well as the opposite doctrine of transformation, etc., etc. Well, such theories are, on the one hand, products of juristic construction, and, on the other hand, powerful tools for further construction. In particular, they are used as arguments for asserting the existence or validity. This distinction is not really important in such a context. Arguments for asserting the existence of unexpressed rules. Generally speaking, The framing of unexpressed rules is aimed at filling real or supposed gaps in the law. But, of course, both interpretation and construction need some further analysis. Interpretation. In common usage, interpretation refers, in my view, sometimes to a genuine act of knowledge, sometimes to an act of decision, and sometimes to a genuine act of rule creation. Therefore, we should distinguish between three kinds of interpretation: cognitive interpretation, adjudicative interpretation, and creative interpretation. Cognitive interpretation simply consists in identifying the frame, Kelsenian term, the frame of the various possible meanings of a legal text, the meanings admissible on the basis of shared linguistic, syntactic and semantic rules, accepted methods of interpretation, existing juristic theories. Now, identifying the various possible meanings without choosing any one of them. This is cognitive interpretation. Adjudicative interpretation, in turn, consists in deciding one definite meaning, choosing among the meanings identified or abstractly identifiable by means of cognitive interpretation, and discarding the other, and choosing one and discarding the other. Finally, creative interpretation consists in ascribing a text a new meaning, new in inverted commas. A meaning not included in the frame of meanings identified or identifiable by means of cognitive interpretation. Take this very simple example drawn from Italian constitution and legal scholarship and case law jurisprudence too. Article 40 of the Italian Constitution states, "The right to strike will be exercised in compliance with the statutes which regulate it." Right. Now, suppose that no statute actually exists regulating the exercise of such a right. And this is the case. It was the case since till not so many years ago. Well, cognitive interpretation of this constitutional provision could run more or less like this. Article 40 of the Constitution can be ascribed three different meanings. One, the right to strike may not be exercised until some statute does regulate its exercise. Two, like in any statutory regulation, the right to strike may be exercised with no limits at all. And three, even in absence of any statute regulating the issue, the right to strike may be exercised, although within limits, namely, its natural limits, deriving from the balance of it with other fundamental rights and constitutional values. Cognitive interpretation. Well, adjudicative interpretation, in turn, would consist in choosing just one of such competing meanings. As a good example of creating interpretation, I shall mention the following. Some friend of me already know it. Article 72 of the Italian Constitution requires a certain legislative procedure for the approval of any statute on constitutional matters. no need to say that the phrase constitutional matters is an open-textured concept, which allows for a great deal of interpretive discretion. On the contrary, the phrase statute on constitutional matters is not ambiguous. In ordinary juristic language, in Italy, in France, in Germany, as far as I can say, in Spain, in ordinary juristic language, statute on constitutional matters univocally denotes ordinary statutes, that is, non-constitutional statutes, statutes approved, passed by the ordinary procedure, statutes bearing upon issues of constitutional significance. Paradigmatic example, which every one of us probably tells students, is statutes concerning the electoral systems of the chambers. Now, nevertheless, according to the opinion of the Italian, of course, Constitutional Court, this phrase, statutes on constitutional matters, should be interpreted as meaning the same as constitutional statutes. That is, statutes adopted by the special procedure required for constitutional amendments. Well, such a meaning of the phrase clearly falls outside the range of meanings identifiable by cognitive interpretation. In the present case, the one and only meaning, in fact, in my view. Now, cognitive interpretation is a purely scientific operation devoid of any practical effect. It belongs to the domain of legal science properly understood. Adjudicative and creative interpretation, on the contrary, are political, in a wide sense, of course, are political operations. They don't point at ascertaining the existing law, rather, they point at shaping the law. Nonetheless, as far as I can see, creative interpretation, as defined the way I did, is somewhat unusual. In most cases, creative interpretation takes a slightly different form. It consists in deriving from a legal text some unexpressed rules. Implicit rules, if you like this term, but implicit in a large, non-deductive, non-logical sense. That is, a derivation which takes place by means of a great variety of arguments, some deductive, but it's not always the case. In most cases, non-deductive arguments, for example, argumentum a contrariis, argumentum a simile, and so on, and or derived and expressed rules derived on the basis of some a priori juristic theory. Well, deriving, constructing, framing unexpressed rules, strictly speaking, is not an interpretive act. It is a genuine form of so-called interstitial legislation by interpreters. And this last remark leads me to juristic construction. Legal scholars' books and papers are crowded by theoretical assumptions. Previous to the interpretation of any particular legal provision, assumptions that have no direct relationship with normative texts. As far as I know, this is especially true for continental legal scholarship. Well, such as theoretical assumptions, first, inevitably condition interpretation, either orienting it in a definite direction or excluding certain interpretive decisions which would be otherwise possible. Second, most of all, such assumptions are grounds for deriving a great deal of an expressed rule. Let me provide some examples. First example, according to the European Court of Justice, I refer to a well-known decision of 1962. I quote, "The European Economic Community constitutes a new legal order of international law which comprises not only member states, but also their nationals. Independently of the legislation of member states, community law not only imposes obligations on individuals, but is also intended to confer upon them rights which become part of their legal heritage. These rights arise not only where they are expressly granted by the treaty, but also because of the obligations which the treaty imposes in a clearly defined way upon individuals as well as upon the member states and upon the institution of the community. According to the spirit, the general scheme, and the wording of the European Economic Community Treaty, Article 12 must be interpreted as producing direct effects and creating individual rights which national courts must protect." In other words, the court assumes the European Community Treaty to be neither an ordinary international act, that is, an act governing relationships among states, neither an ordinary international, nor a constitutional act, that is, an act governing relationships between citizens and the state. According to the court's view, the treaty is an entirely new kind of legal act with a mixed nature, half international, half constitutional. Well, this theoretical assumption leads the court to interpret several provisions of the treaty as, I said interpret, the right word would be construe. Construe several provisions of the treaty as creating rights and obligations, not only in the relationships among states in the international community, but even in the relationships between each state and its own citizens. Second example. My paper is crowded by examples. There is no special theoretical construction, just examples. I'm discovering the umbrella, as I said. Second example. The Italian Constitution has framed a parliamentary government. Why? Well, because the executive is subject to the confidence of the chambers, and in case of a vote of censure, is supposedly under the obligation to resign. Now, most Italian constitutional lawyers, almost all of them in fact, most Italian lawyers maintain that under the supposed general theory of parliamentary government, the President of the Republic is not the head of the executive, like in the USA or in France. He or she is rather a neutral power, something like Benjamin Constant, pouvoir neutre, whose function is just guaranteeing, protecting the Constitution, that is, assuring the normal functioning of the ordinary political constitutional process. Well, such a theoretical assumption has a great normative import. For example, the President, under the Italian Constitution, is granted a veto power over legislative acts. However, according to the theory, he or she may not exercise such a power on political grounds, since the function of the veto power is allowing the President to exercise an a priori control over the constitutionality of statutes. Just the constitutionality, not the political merit, so to say. In particular, as a consequence, the President may use his or her veto power only against statutes whose unconstitutionality is self-evident. Another example. The acts of the executive in Italy are decided by the Council of Ministers, but they are enacted by the President. That is, they are, properly speaking, from the formal point of view, presidential acts, not governmental, but presidential acts. The President, however, thus runs the theory, may not refuse his or her signature except when facing acts clearly unconstitutional. And so on and so on. In other words, the general theory, so-called, of parliamentary government allows legal scholars to add a great deal of rules to the rules expressly stated by the Constitution, a great deal of rules, in particular, limiting the presidential power. Third and last example, last for a moment. The Italian Constitutional Court assumes, without providing any argument at all, by the way, assumes that the Constitution contains or implies, that's not so clear, contains or implies a number of so-called supreme principles, which are allegedly superior to the remaining constitutional provisions. This is the assumption. And the court concludes that such principles may not be suppressed, derogated, or changed in any way. That is, not even by means of the procedure of constitutional amendment. As a consequence, the court empowers itself to declare null and void any constitutional amendment purporting to subvert the supreme principles. No need to say that in no way does the existing constitutional text allows for such thesis. So, unexpressed rules. An unexpressed rule is a rule that no normative authority ever formulated. A rule which cannot be ascribed to any legal text as its meaning content. Every unexpressed rule is the result of an argument in which usually some expressed rules are the premise or the premises, and the unexpressed rule is the conclusion. But it has to be stressed that in most cases such arguments first are not logically valid, are not deductive arguments, and second, most of all, they include premises which are not expressed rules, but arbitrary juristic conceptual constructs and theories. At least three different kinds of reasoning and three different corresponding classes of unexpressed rules can be distinguished. Some unexpressed rules are derived from explicit rules by means of a logically valid argument in which all the premises are but expressed rules. Unexpressed rules of this kind, however, are of no interest in the present context, since such rules, although not formulated by normative authorities, are logically entailed by explicit rules without adding any further premise. So their juristic formulation is the result of a merely cognitive operation. Other unexpressed rules, however, are derived from explicit rules by means of logically invalid arguments, a simile, a contrario, and so on. For example, suppose a constitutional provision granting all citizens, this is the word used by the Constitution, by constitutional language itself, granting all citizens the right to vote. Well, arguing a contrariis, one can maintain that such a provision implies the unexpressed rule according to which non-citizens are positively, although implicitly, excluded from the exercise of the right to vote, in such a way that a possible statute claiming to grant the same right to non-citizens would be unconstitutional. Another example, a statutory provision grants big corporations a tax break. Arguing a simile, one could maintain that in the light of a supposed ratio legis, for example, economic development during a period of financial crisis, in the light of the ratio legis, big corporations are essentially similar to medium-sized companies, and therefore the provision at hand implies the further rule to the effect that the same tax break is to be applied to such medium-sized companies too. In both cases, a contrariis or a simile, a new unexpressed rule is added to the legal system. But third kind of unexpressed rule and third kind of argument, and this is the most important point, I think, a lot of unexpressed rules are derived deductively, sometimes deductively or not, but this is not really important in this context. A lot of unexpressed rules are derived either from explicit rules plus some theoretical assumption, or directly from a theoretical assumption alone. I already gave some examples of such phenomenon. Consider, however, some examples more. First, according to the classical constitutional theory of the Enlightenment, the function of every constitution is limiting political power. Article 16 of the Déclaration des droits de l'homme et du citoyen. This view implies, not logically entails, but implies that constitutional rules are addressed only to the supreme state organs and in no way subject to judicial application. Nowadays, on the contrary, most constitutional lawyers in Italy and elsewhere think that the function of the Constitution is also, or even essentially, molding social relationships among citizens, among private citizens. And from this view, they draw the conclusion that constitutional rules should be directly applied by any judge in any controversy. Second example, Article 139 of the Italian Constitution prohibits whatever revision, even by means of constitutional amendment procedure. Any revision is prohibited of the republican form of the state. However, most constitutional lawyers, almost all of them, assume that a republican state is, by definition, a democratic one, and conclude that no revision of the democratic form of the state is allowed. No need to say that this conclusion, whose only ground is a disputable juristic concept of republic, has the outstanding effect of excluding from constitutional amendment nearly the whole constitutional text. A third example, the Court of Justice of the European Community assumes, on the one hand, that the European Community law and the law of the member states form a unified legal system, first. And second, on the other hand, that European law is superior to state law. From these two assumptions, the Court draws the conclusion that state legislation is invalid or at any rate non-applicable when incompatible with community law. No need to say that both assumptions have no textual counterparts in the European Treaty. Fourth and last example, the Italian Constitutional Court, once more, assumes, on the contrary, that the European Community law and the law of the member states are independent legal systems, and draws the conclusion that community law cannot derogate or invalidate incompatible state legislation. These assumptions, too, has no textual basis in the treaty. Generally speaking, formulating unexpressed rules is often aimed at concretizing, is it English? I hope so. At concretizing principles. Concretization of principles, in turn, is often a means to fill up real or supposed gaps in the law. Supposed gaps in most cases. Take the following example. I met it a few weeks ago. Article 87 of the Italian Constitution states, among other things, that the President of the Republic enacts certain, not all of them, but certain governmental acts. Well, most constitutional lawyers, however, are not satisfied with such a simple provision. They wonder about the limits of this presidential power. In particular, they ask themselves in what circumstances the president is authorized to refuse the enactment. And since the Constitution gives no answer to such a question, they conclude for the existence of a gap in the constitutional text and try to feel it. They don't even suspect that since the Constitution states no limits, hence no constitutional limits exist. Should we really consider as a gap any case that the Constitution simply doesn't take into account? Well, the supposed gap doesn't depend on the fact that the Constitution fails to regulate the case, although taken into account. Not at all. It depends on the juristic assumption that the Constitution ought to regulate the case. In other words, the gap in question is an axiological one. It depends on evaluations. Framing unexpressed rules amounts to apocryphal legislation by interpreters. And as a matter of fact, I think, it constitutes the main and most significant part of legal scholars' work. This is especially true as far as constitutional interpretation, or rather constitutional construction, is concerned. It is a well-known feature of most European constitutions of the 20th century that they include a great deal of principle, that is, provisions affected by a high degree of indeterminacy, open circumstances of application, divisibility, and so on. Provisions, in particular, that, because of their indeterminacy, cannot be applied without previous concretization. On the one hand, principles, because of their peculiar form of indeterminacy, cannot be used as direct justification of judicial decision of individual cases. For example, not important, but anyway, an example. Defense is an inviolable right at every stage and instance of legal proceedings, Article 24 of my own Constitution. Defense is an inviolable right. Says nothing about the presence or absence of the advocate to the police interrogation of the accused person. To decide whether the advocate ought to be present or not, the principle must be, say, transformed into a relatively precise rule. An example drawn from French constitutional law, the principle national sovereignty belongs to the people, Article 3 of French Constitution, says nothing about the right to vote of immigrants from inside the European Union in the elections of city councils, to decide whether such immigrants are, or well, could be entitled to vote or not. One has to derive from the principle a definite rule. On the one hand, this is one class of problems. On the other hand, the second class of problems, in most cases, normally, the judicial review of legislation requires comparing not two rules, but a rule and a principle. However, rules and principles are heterogeneous sentences. As a consequence, such a comparison is simply impossible without previous concretization of the principle at stake. How to compare a statutory rule which doesn't provide the presence of the advocate to the police interrogation with the constitutional principle of the defense as an inviolable right? How to compare the principle principle of national sovereignty with a statute or a treaty entitling European immigrants to vote in the elections of a city council. Once more, principles need concretization. Well, concretizing a principle means extracting from it one or more unexpressed rules. Such a concretization amounts to an argument where the premises are the principle at hand coupled with one or more arbitrary theoretical assumption. For example, defense is an inviolable right at every stage and instance of legal proceedings. The police interrogation of the accused person is a part of the legal proceedings, hence the advocate ought to be present. My conclusion. I've been talking too much? But anyway, 5 minutes more, please. Generally speaking, try to give some example of it. Legal scholarship amounts to shaping the legal system. And this happens in two connected ways. First, legal scholars shape the legal system, determining by means of adjudicative interpretation the meaning contents of the enacted normative texts. Second, they do so by producing new rules by means of pre-existing rules. That is, if I may echo a happy formula by J.L. Mackie, inventing right and wrong, or more precisely, inventing rights, powers, obligations, and a lot of legal relationships. In Bentham's, Austin's, and Kelsen's view, law is a language. Yes, a language. The set of sentences enacted by the law-given authorities. And expository jurisprudence, or the science of law in Kelsenian terms, is depicted as a second-order descriptive language whose object language is the normative language of the law, of the legal sources. Remark, by the way, that criticism and approval of existing law too amount to a second order evaluative, not descriptive, but anyway, a second order language about the law. Well, this view of the science of law is a normative model on which I myself agree. But it cannot be considered as a reliable description of actual legal scholars' practice. In actual legal scholars' language, at least three kinds of sentences can be distinguished. First, normative propositions, or propositions of law, that is, true or false sentences describing the law in force. We have different, Jorge Rodriguez and me, we have different conception about the logical form of normative proposition. But anyway, normative proposition. Description of norms or rules in force. First. Second, adjudicative, interpretive statements which are not propositions. They are not propositions at all. Why? Because they don't describe anything. They ascribe meaning. And third, normative formulations, new normative formulations which don't describe anything at all, once more, but definitely settle new unexpressed rules. You know, there is no possible confusion between the revolving of the Earth around the Sun and the astronomical science which describes it, since the moving of planets is no language entity, while astronomical science obviously is. As far as the relationship between legal scholarship and the law is concerned, on the contrary, such a confusion is possible and actually obtains. This is so since both law and legal scholarship are but languages, discourses if you prefer. In other words, no clear-cut distinction can be established between the language of the law and the language of lawyers. These two languages are subject to a continuous osmotic process. Lawyers' language does not bear upon the language of the law. It's not a second-order language. Rather, legal scholars do frame, mold, and continuously enrich their subject matter, the subject matter of their study. And this amounts to say, this is probably the only interesting part of my papers. This amounts to say that interpretation and juristic construction are not the legal science as academic lawyers usually claim, but they are part of the law itself, and therefore a part of the subject matter of legal science. In other words, describing the law in force requires taking into account legal scholarship as well as case law jurisprudence as a significant part of it, provided, as a matter of course, that the rules framed by legal scholars come into force through the decision of judges and other applying organs at large. Thank you very much.
Well, the authority of this conference has enacted an order according to which the debate must finish in 40 minutes. And I interpret this order in its literal meaning. So, Eugenio and Robert and Eugenio.
Michel Troper y Carla Huerta también.
Troper, después de Troper, ¿sí? ¿Quién después de Troper?
Michel Troper y Carla Huerta.
You spoke of normative propositions as descriptive of the law in force. Why this limitation to law in force? There are many cases when lawyers try to describe law which is not in force. For instance, I will follow your methodology and give some example at least twice, not so many as you. First example, sometimes they try to describe a project of law, which is not in force, but it's very important to know what it says, what are its consequences, trying to derive the consequences of this project of law. And this might be termed as normative propositions as well. Second example, after the World War II, well, after the Second World War, after some time, there were many problems originated by the fact that with the fall of communist regimes, many people tried to recover their property which was confiscated years ago. And in order to resolve this kind of question, one must describe the law that
which is no more in force, okay.
That is no longer in force, but it's very important to describe it. So why this limitation to law in force?
Okay, Eugenio, thank you. Of course, you're right, but I suppose you too would admit that the description of the law in force is the most important part of legal science. At any rate, okay, you're right. Now, there is a problem, a conceptual problem, about what you said about describing rules that are not yet in force, for example, a project of law. This would amount, in my view, in what I call cognitive interpretation. That is, analyzing the text and extracting from it the frame, Kelsenian frame of possible admissible meaning in the light of the language in use and so on. Okay.
Yes, thank you very much for your lecture. There are some points in your paper with which I agree, but there are also some points in which I don't agree. The first point concerns the concept of construction. I think it is necessary to distinguish two kinds of construction. Let me take your example on page 17 to illustrate it. You mentioned in the second line from the top the horizontal effect, that is Drittwirkung of constitutional rights. The horizontal effect, that is the question whether constitutional rights are only relevant in the relation between the citizen and the state, or also between citizen 1 and citizen 2. And we have two constructions of horizontal effect, that, or even three constructions, but I mentioned for reasons of simplification only two. The direct construction, that constitutional rights immediately have legal effects in the relationship of citizen 1 and citizen 2. And the indirect construction, which means that the judge, they are addressed to the judge, that he has to consider when he decides a civil law case, that he considers the relevance of constitutional rights. These are two ways to think about this problem. But a liberal conservative judge can come to a certain, he must make a weighing. And a liberal conservative judge will give less impact on equality in contract law. Whereas a socialist judge would give a lot of impact to equal treatment in contract or labor law relations. This is the evaluative aspect. But the other aspect is purely constructive. That is pure construction and evaluative construction. And my thesis is that the pure construction is the highest form of legal science, and I miss it. For instance, how to think about proportionality analysis. What is the structure of balancing? If you have an analysis, a theory of balancing, you can have and must have one if legal reasoning should be rational. You need no evaluation at all to develop an adequate theory of balancing. And I think, or how to construct the relationship between a right and its limits. That says nothing about how much rights should be delimited, a little bit, medium degree, or very intensively. And all these, I think has been the mistake of German Begriffsjurisprudence, conceptual jurisprudence in the 19th century, that they made exactly what you have done. They mixed the conceptual formal analysis, they made a mix and evaluation. I think exactly this we must separate when we deal with the concept of construction. I would have, if we had more time, a second point. I don't agree, I simply want to say, this was my argument, this is my point, but the second is simply a remark. I don't agree with you, you refer to Mackey. I don't agree with you that practical reasoning, that is evaluative reasoning, is not possible. You'd use 2 times the term arbitrary. You use it at page 15, at page 20. I don't think that legal reasoning in normative or evaluative question is eo ipso, per definitionem, arbitrary. I think there exists the possibility of rational, practical argumentation. And if this possibility should exist, that would be relevant for the concept of legal science.
Thank you. Well, okay, the reference to Mackey was not important. It was just, ¿cómo se dice broma en inglés? Just a joke. Nothing more than a joke. A citation, but that's okay, it's not important. As far as the problem of arbitrariness or rationality of this kind of juristic construction, yes, maybe you're right, arbitrary is a too strong word to refer to this kind of thing. I don't deny the existence of some form of rationality, namely instrumental rationality within the legal or the ethical domain. So in a sense, I agree that arbitrary is too strong, although at the level of metaethics, I am emotivist. So, okay. Now, as the difference between two kinds of construction, I should reflect on it. It looks very interesting. Just one remark. I think we have two different conceptions of what a legal science, a cognitive enterprise describing the law should be. It seems to me that your conception of legal science is somehow like that of Savigny, isn't it? That is, well, a kind of science which is not purely descriptive. It's a constructive enterprise which consists in developing the law whose ultimate basis or sources are elsewhere in the Volksgeist. But in fact, I have a very narrow concept of legal science. I think legal science consists in describing the law in force. And the law in force is is a pure description, and the law in force is the law actually applied by the courts. By the courts and other applying organs. For example, as far as constitutional law is concerned, it isn't only the courts who apply the kind of rules. Anyway, as applied by law applying organs, this is the description of the law from a static point of view. From a dynamic point of view, one should take into account legal science understood this way.
Sí, José Juan por eso después. José Juan.
E forse c'era prima Michel.
It's the order.
Well, I enjoy a lot your lecture, but at the end I have a problem, because you said, Riccardo, that according to Bentham, Austin, Kelsen, the law is a language, the set of sentences enacted by the law-giving authorities, and you said that the law is also the interpretation and juristic construction, and in order to describe the law in force requires taking into account the interpretation and juristic construction. I think that these both aspects produce, a dilemma. Either you consider describing the law only the repetition of the sentences of the legislator and the sentences of the interpreters, the sentences of normative propositions, but only the sentences, because this is describing, and this is unuseful, I think, because we have the text of the law and the text of the interpreters. Or you cannot maintain that these are descriptive task, because you should consider now evaluative activity of interpretation in order to describing the law, because it's necessary to determine that it's a normative proposition, that another is a adjudicative interpretive statement, and in order to know if this is a normative proposition or is not a normative proposition, or what is the meaning of this interpretation of the legal doctrine, is necessary to interpret. And interpret is for you evaluating. And we have or repetition or never describing, or repetition, either repetition or evaluative interpretation. Thanks.
I must confess, so-called normative propositions, in my view, are factual propositions. I mean, I think that a fact is, it's Carnap's idea. A fact is anything about what one could formulate a proposition. So, if a normative proposition is possible, such a norm which it bears upon should be some kind of fact. In other words, describing the law, formulating normative propositions about the law, I think consists very simply in describing the interpretations and construction actually accepted, well, by the legal community at large, and most of all by the law applying organs. I can see no serious philosophical problem in it. I'm sorry. It happens so often that I cannot see the philosophical problem. But it's not repeating. Article X of the statute Y is actually interpreted by lawyers and judges this way. And is there any alternative? What could be the alternative? The alternative could be, we were discussing of it this morning, although very briefly with Jorge Rodriguez, conceiving of normative propositions as propositions, provided that such sentences could be deemed to be proposition, and I'm not at all sure of it, as propositions which describe or claim to describe the deontic status of actions, of behavior. I don't think that the deontic status of something can be the object of a proposition. Propositions only can describe facts. So, normative proposition is maybe an unhappy phrase to refer to propositions which describe attitudes, beliefs, and behaviors connected with norms. The enactment of normative text, the possible meanings of this text, the actual interpretation, and so on. But this is this conception, I dare say conception, but too strong maybe, of the legal science has nothing surprising. It is what lawyers usually do when they write a handbook for students. This is what they do.
Michel Tropez.
So I had two questions. My second question is very much along the line of what Juan Moreso just said. So I will be brief on the second. Let me just start with the first. And it's about your distinction between three types of interpretation. I'm not quite sure how you distinguish between B and C, between adjudicative interpretation and creative interpretation. In the example that you give of a creative interpretation, Article 72 of the Italian Constitution, you say that the Italian Constitution has created a new norm, but how do you know that? You could say as well that there were two meanings of Article 72, two possible meanings, and that statute on constitutional matters means, from a cognitive point of view, either an ordinary law about constitutional matters such as electoral laws, or that it means an amending law or a law to amend a constitutional amendment. So in that case, what the Italian Constitutional Court did is choose between meaning one and meaning two, which is precisely what you call adjudicative interpretation.
There was no meaning two.
With the meaning two is it could have possibly been found by cognitive interpretation before, by reading the text. And I think one argument for this is that when you read the decision of the court pretends, you will say wrongly, but how do you know that? Pretends to be interpreting and uses the word interpretation. And you give such an example a little later about the European Court of Justice on page, where is it? Yes, on page 12, when you quote Van Gent and Loos, well, the court refers to Article 12 and says Article 12 must be interpreted. So when you say that this is not really interpretation, that it is creation, you mean that the court is lying. But how can you say that? What is your evidence for that? The second question is more of a question, following what Juan Moreso said. If you expand the domain of law, the object law, to include these juristic constructions, then a science of law must describe that object completely. But the constructions are already at a meta-linguistic level, since these constructions are partly descriptive, partly evaluative, of a set of rules that exist. And then you will have to describe these constructions at a meta-linguistic level. So my question is simply, what is the truth value of the propositions that you will express at this meta-linguistic level?
In fact, you raise not just two, but three problems. This last one, I don't understand your question in a sense. Yes, of course, the truth value of such proposition depends on their correspondence to reality. Well, what is the reality? The actual interpretations and construction of lawyers or jurists and the actual decision of cases by the courts. Là, je ne vois pas le problème. Bon, but the first and second remarks you made are more interesting in my view. How can you say, you said, that in the case of the interpretation, so-called, of Article 72 of the Italian Constitution, the rule ascribed by the court to the text is a new one? Well, new is a relative concept. It's a concept which depends by the comparison, by the previous ascertainment of the frame. Now, of course, the frame, you always insist on this point, and I cannot not agree with you. The frame is a concept, well, the concept is clear, but the reference of the concept of frame, the Kelsenian frame, is open-textured. In other words, there can be disagreements, and even important disagreements, as to the very content of the frame. For example, in this particular case, ascribing to the phrase statute in constitutional matter the meaning of statute by constitutional procedure was or was not a meaning included in the frame. Well, we have a disagreement on it. It is evident. I cannot see no way out. In my opinion, it is clearly out in this particular case. This meaning was out of the frame. In most cases, but this is not the case, in most cases, the borderline of the frame is uncertain. I agree. But in most cases, it isn't. And we are able to distinguish between, say, ordinary jurisprudential decision and interstitial legislation by the judges. And this is not deprived of any interest, in my view, if one thinks that whatever the judges decide, this is the law, okay. Distinguishing when do confine themselves to interpret in the ordinary sense a text, and when they create new law, for example, when they fill a gap, has no importance. Because in every case, judges make the law, and even all law is judge-made law. But, and that's okay, I agree in a sense, but it seems to me is not deprived of any interest distinguishing and classifying the different kinds of decisions judges make. By the way, all law is judge-made law. Well, my thesis is that this thesis is false. All law is jurist-made law, exaggerating just a little. The court says we interpret the Article 72 of the Constitution. So they say, but what is the importance of this statement of the court itself? Of course, the court, as lawyers and jurists in general do, does not distinguish between different kinds of interpretation, between interpreting and constructing, and so on. So, from this point of view, what the court says has no importance. Even if the court thinks of itself, I'm just interpreting, I'm accomplishing, or even I'm accomplishing a simply cognitive enterprise, because that is the real and objective and liable to knowledge content of the law. What does it matter? The court may say what it wants, but the reality, from reconstructing the reality with a certain apparatus of concepts, shows a different reality.
Next intervention and next answer should be as brief as possible because of
5 minutos.
Of time. Everyone?
Yes.
No, we have
No, in total.
15
15
minutes. Carla Huerta? Not? Okay. You?
You advance a theory of legal scholarship and how it impacts the law, but the examples you give in support of your theory are examples of judicial decisions.
Yeah, you're right. But sometimes they are, sometimes they're not, but okay.
Oh, I guess that's the question. I guess most of your examples are of judicial decisions, and
It's true.
so I can't see how your examples could possibly substantiate a theory of the impact of legal scholarship as opposed to a theory of the artifacts of judicial custom, which is a standard source of positive law.
You're right. In fact, most examples are drawn from judicial decision. Now, well, in my view, juristic construction of unexpressed rules and so on is a typical business of legal scholars. And this is why the paper is, at least formally, focused on legal scholarship. But as a matter of fact, it is true that in most cases, judges act and think like legal scholars. And as far as constitutional courts and even international courts, included the European Court of Justice, most judges are professors, in fact. So they do perform one and the same job in most and different occasions. Well,
This is the last one. Sorry, but the authority of the conference has expressed an order by no verbal means, but a very clear means, ordering the finish. So Isabel Infante is the last one. Sorry.
no, that's good.
Thank you. One question. You distinguish between two senses or two activities, interpretation activities. The first one, interpretation sensu stricto, and the juristic construction. But in the first one, in the interpretation sensu stricto, you distinguish three activities. The third one, the creative interpretation, implies the second activity, juristic construction. But my question is, I think that the second one, adjudicative interpretation, implies two juristic construction in order to choose one of the different possibilities. I suppose that the activity you need is this kind of activity, juristic construction. And in the first one, in the cognitive interpretation, you have to describe also the construction theories existing in the community. So I don't know if the second activity, the juristic construction, is not more important for the interpretation that you seem to accept.
Okay, thank you. This is a good idea. You said, if I understood you well, you said that construction is, or is in most cases, previous to adjudicative interpretation and conditions adjudicative interpretation. I think it's true. I think you're right. However, one should see case by case whether the result of a previous construction is an adjudicative interpretation or rather a creative one. But it's a matter of empirical analysis. By the way, maybe it's not so clear reading or listening to my paper. The difference between creative interpretation and juristic construction is is not a sharp, clear-cut difference. There is a continuum between the two, although conceptually different things. As a matter of fact, what, according to our intuition, seems to be creative, in most cases, is not exactly interpretation, but something else, something different.
Okay, thank you very much, Riccardo.
Thank you all.
Very much, everybody.